Good afternoon everyone, this is Swati Bajaj, I am an advocate. I have prepared a module on the topic shareholders and creditors remedies of personal actions, derivative actions or class actions, including cases of operation and mismanagement. Firstly, I will give you an overview of this topic. Like the shareholders and creditors are the most vital organs of an artificial body called company. A company can grow only if its shareholders and creditors are happy and satisfied from the working of the company. As soon the company involved in any misfeasance like operation or mismanagement, its future starts seeing its nightfall. So, in this module, we will discuss the following topics in detail, that is concept of operation and mismanagement, then the minority shareholder versus majority shareholders, and then the remedies of shareholders. These include three main important remedies, that is personal actions, derivative actions and class actions. Now, firstly we will discuss about the concept of operation and mismanagement. Now, the meaning of the term operation as explained by Lord Cooper in Scottish case, that is Elder versus Elder and Watson Limited. This is a case of 1952. This was cited by with the approval of Justice Vanchu of the Supreme Court of India in the case of Shanti Prasad Jain versus Kalinga Tubes Limited, and this is the case of 1965. The term operation was explained in this case as the essence of matter seems to be that the conduct complained of should at the lowest involve a visible departure from the standards of fair dealing and a violation of the conditions of fair play on which every shareholder who entrusts his money to the company is entitled to rely. This basically explains that whenever a person in a public companies, whenever a person wants to invest their money in that company, then they do not invest blindly. They get to know about the company and its affairs, its objects and details. They go through the whole memorandum of association and the article of association, and only after satisfying themselves that they are investing in a trusted organization, they invest their money. So, in such a case, suppose if a person is investing in the company because of this fact, and then suddenly those things get changed after they have invested the money. So, the main prima facie objective on the basis of which they have invested their money in that company fails. So, in that case this is the operation on the part of the company, and in this case the shareholders become the victims of that operation. After the term operation, the next term to be explained is the mismanagement. To explain this term, we need an illustration that is also a case law, that is Rajamundry Electric Supply Corporation versus Nageshwara Rao. This is a case of 1956 and it has been decided by the Supreme Court of India. In this case, a petition was brought against a company by certain shareholders on the ground of mismanagement by directors. The court found that the vice chairman grossly mismanaged the affairs of the company and had drawn considerable amounts for his personal purposes. That large amounts were owing to the government for charges for supply of electricity, that machinery was in a state of disrepair, that the directorate had become greatly attenuated, and a powerful local junta was ruling the roost, and that the shareholders outside the group of the chairman were powerless to set matters right. This was held to be a sufficient evidence of mismanagement by the Supreme Court of India. Minority shareholder and majority shareholder. The group of shareholders in a company is divided in two parts: majority shareholders and minority shareholders. Majority and minority here does not mean that the majority is like 5 to 2 or something like that. This is not the majority or minority here. Here the majority and minority refers to that the majority shareholders are those shareholders who have the controlling power in their hands, controlling power of the company. They are controlling the affairs of the company, and the minority shareholders on the other hand are those who don't have the controlling power. They just have some shares of the company in their own hands. They have their investment in the company, but they are not controlling the affairs of the company. So in this case, what happens that sometimes these minority shareholders who are not in the company, who are not inside the company, they are the outside players of the company. So their interests sometimes get neglected, because every time they don't bother that what the majority shareholders are doing in the company or what's not. So in that case, sometimes these majority shareholders, by abusing their controlling power of the company, misuse their power, and then the minority shareholders have to suffer. So this concept of operation and mismanagement has a very great dealing with this concept of minority and majority shareholder, because this operation and management are those two atrocious activities which these majority shareholders conduct. These majority shareholders are the persons who get involved in the oppressed or mismanaged activities, and the result is that the remaining shareholder is a minority one will have suffered the loss or suffered the consequences of the acts of the majority shareholders. So even N.A. Bastian in Minority Protection in Company Law explained this concept of minority shareholders as the protection of the minority shareholders within the domain of corporate activity constitutes one of the most difficult problems facing modern company law. The aim must be to strike a balance between the effective control of the company and the interest of the small individual shareholders. Now further I will deal with the case of rule of force versus Harbotter. It is a very important case on this point, and the case of 1843. It is in this case where the basic principle was laid down by the court, and that basic principle has certain exceptions, because the principle is something which was in violation of the interest of the minority shareholders. So in that case the basic principle is there, but then certain exceptions were given, that in which cases this principle cannot be followed. So the basic rule which is laid down in this case was that the courts will not intervene at the instance of shareholders in matters of internal administration, and will not interfere with the management of a company by its directors so long as they are acting within the powers conferred on them under the articles of the company. Now what we need to understand here is that the companies are something which always involve in some competition. One company is in competition with another company is in competition with another company, and also with the first company. So in this competition, the companies have to take their steps very thoughtfully. So in that case, it is not allowed that if the members of the companies came in any dispute and they went to the court for the settlement of their dispute, what will happen only that the status of the company will get reduced, the goodwill of the company will get finished, and the competitors will take the benefit of this. So keeping in mind this is one among the other grounds. So keeping in mind these all grounds, what is decided in the case that the court should not interfere in the matters of the company itself. It is a company in its management. There is company law board. They can settle their disputes by themselves. There is no need to enter the court or to ask the court to settle these disputes. But there are some circumstances where the court's intervention is required, and because this rule is something which is making the minority shareholders more and more weak, because they cannot challenge the actions of the majority shareholder in the courts, because court is not at all allowed to intervene in the matters of the company. So, in such circumstances, there are certain exceptions to this also. We will discuss these exceptions also. For this, it is given that the court has also given certain, like I have told you, the exceptions to this rule, among which one is oppression and mismanagement. So, the oppression and mismanagement is one of the exception to this rule, which was laid down in the case of Force versus Harbottle. Now, it has been stated by Justice Sinha of the Calcutta High Court in Kanika Mukherjee versus Rameshwar Dayal Dubey. This is a case of 1966. It was observed or stated by Justice Sinha that the principle embodied in section 397 and 398 of the Indian Companies Act, which provide for prevention of oppression and mismanagement, is an exception to the rule in Force versus Harbottle, which lays down the sanctity of the majority rule. So, we have discussed up till now three main points, that is the concept of oppression and mismanagement, the concept of minority versus majority shareholders, and the rule of Force versus Harbottle. After discussing the three main essential points, what we came to the conclusion is that this oppression and mismanagement, these are the two atrocious activities we need to be prevented. And because these two activities are those which are which the members get indulged in these activities, so in such a case it becomes very difficult that as we have already told it, that the court should not intervene in the small disputes of the companies. So, whether the acts of the majority shareholder of the oppression and mismanagement can be taken in the court by the minority shareholder, this principle is not accepted by the court in the case of Force versus Harbottle. So, there in the case of Force versus Harbottle, the court says that no, the court should not intervene. But in the Indian case, like I have told you, that Justice Sinha in the case of Kanika Mukherjee, they said that no, this rule needs some exceptions to it, because if it doesn't give any exception to this rule, then the interest of the minority shareholder will get violated, and then the shareholders will not, the person will not become the shareholder of the company, and they will not invest in the company. And if they will not invest in the company, then how the company can be administered? So, the oppression and mismanagement become the exception to this rule of Force versus Harbottle. Now, we will discuss the remedies which are available to the shareholders in case of this oppression and mismanagement. Section 241 of the Companies Act 2013 provides that any member of a company who complains regarding any oppression or mismanagement being occurred in a company may apply to the tribunal. Moreover, even the central government, if of the opinion that the affairs of the company are being conducted in a manner prejudicial to the public interest, then it may itself apply to the tribunal for an order. In this module, we will discuss three different actions which the shareholders can take, that is personal action, derivative actions and class action. Personal action. In this, the shareholder claims their personal right which arise from the constitution of the company. This constitution of the company is memorandum of association and articles of association. So, the rights which each and every shareholders have, which right they get from the memorandum of association or the articles of association, these are the personal rights of the shareholders, and the shareholders can claim those rights without any help from any other shareholders. So, these are the personal rights, and for these personal actions can be taken by the shareholders. But however, in Indian companies law, personal actions of the shareholders aggrieved from the acts of oppression or mismanagement do not possess any statutory provision. Now, we come to another action, that is derivative action. It is a very important. An interesting area of law is the law governing derivative action, which enables the shareholders of a company, that is mean group of shareholders, to bring an action on behalf of the company against a third party before a regular civil court. Again, there is no specific statutory provision for the derivative action claim in the Indian Companies Law. However, the doctrine of derivative action is recognized by the Indian courts. If a shareholder alleges that a wrong has been done to the company by persons in control thereof, he may bring a derivative action where he derives the authority from his corporate right to sue on behalf of the company. The premise on which the court entertains this extraordinary form of action is upon the complaining shareholder's assertion that the company cannot sue as the persons in control would not bring an action on its behalf for its benefit. Now, derivative action is basically defined as an action by one or more shareholders of a company where the cause of action is vested in the company and relief is accordingly sought on its behalf. Since the company has a distinct legal personality with its own rights and liabilities which are different from those personal rights of individual shareholders, this action is brought by a shareholder not to enforce his or her own personal right. I will repeat that since the company has a distinct legal personality with its own rights and liabilities which are different from those personal rights of individual shareholders, this action is brought by a shareholder not to enforce his or her own personal rights, but the right and liabilities of the company on its behalf and for the benefit of the company, which the company cannot itself do as it is controlled by wrongdoers. Now, in order to be classified as a derivative action, the following aspects must be satisfied. Firstly, it must be brought in a representative form, that is, though it is a company rather than the other shareholders whom the person initiating the legal action or proceeding seeks to represent. That by implication of all other shareholders are bound by the result of the action. That is, a group of shareholders came together and they filed a suit in a representative form. Here, whatever be the result of that action, all the shareholders will get affected by that. Now, although the action is brought on behalf of the company appears as a defendant, so that the action takes the form of a representative action by the initiating shareholders on behalf of himself and all other shareholders other than the alleged wrongdoers. I mean, though shareholders doesn't include the wrongdoers also, and this action is against the alleged wrongdoers and the company. So, shareholders are taking action in a representative form against the company as well as against the wrongdoers, and these wrongdoers are the part of the company itself, they are also the shareholders of the company. The derivative action may be brought by a shareholder or shareholders in the following instances. First is ultra vires. A shareholder may bring an action against the company and its directors in respect of matters which are ultra vires the memorandum of association or the articles of association of the company, and which no majority shareholders can sanction. For example, directors of the company sanctioning an action that is contrary to the objects of the company. So, objects, as I must told you that the objects of the company are the basic things on the basis of which the company is tending its building or its business. If the company fails to satisfy those objects, then the main purpose of the establishment of that company get failed, and then the existence of the company is not at all allowed, not even by the court or by the other person associated with the company, like its creditors. So, if the directors of the company sanction an action which is contrary to the objects of the company, that is an ultra vires act, and in that case the derivative action can be taken by the minority shareholders or any shareholders which are get affected by that action. Next is the fraud on minority. Directors and the company would also be liable if the conduct of the majority of the shareholders constitutes a fraud or minority, that is a discriminatory action. For example, where the shareholders have passed a special resolution with an effect of discriminating between the majority shareholders and minority shareholders so as to give the former an advantage of which the later were deprived. I repeat the example again, where the shareholders have passed, these shareholders are majority shareholders, that is shareholders who are in control of the business. So, where the shareholders have passed a special resolution with an effect of discriminating between the majority shareholders and minority shareholders so as to give the former an advantage of which the later were deprived. Former is the majority shareholder and the later is the minority shareholder. So, in such cases it is a fraud on the part of the majority shareholders on the minority shareholders, and in such case also the group of minority shareholders in a representative form can take a derivative action in the court. Another is required resolution, that is certain actions of the company can be approved only by passing a special resolution at a general meeting of shareholders. So, if the majority seek to circumvent this legal requirement and pass only an ordinary resolution or do not pass such a special resolution in the manner required by law, then any member or members can bring an action to restrain the majority. The majority shareholders and minority shareholders, they both are the part of the company. The interest of both the majority as well as the minority shareholder need to be protected. So, there is no need for the majority shareholder to take actions by themselves and do not involve the minority shareholders with them. It is a duty that whenever they take any crucial actions which need any special resolution and which need the assent of the minority shareholder, they have to get that assent. They cannot exclude the minority shareholder, they cannot neglect the interest of the minority shareholders. Another one is to safeguard interest of the company. For example, an obvious wrong may have been done to the company by the directors, but because of the control of such directors on the majority shareholders, such shareholders may not permit an action to be brought against the wrongdoer directors. Therefore, to safeguard the interest of the company, any member or members may bring a derivative action. So, as both the majority shareholders and minority shareholders are liable or as well as responsible for the company, they are responsible on behalf of the company. They have to maintain the goodwill of the company. So, if the minority shareholders came to the opinion that the acts of the majority shareholders are not in favor of the company or that they are doing any act which is frivolous to the interest of the company, then in such case minority shareholders can take an action against those majority shareholders for the interest of the company. Next is the individual membership rights. As a general rule, personal rights per se are not to be enforced through derivative actions. However, some exceptions have been recognized. These exceptions often arise in case of rights that have been conferred upon the shareholders by the Companies Act itself or the respective articles, which is known as individual membership rights. For example, the right to vote, the right to have one's vote recorded, or the right to be nominated as a candidate for the post of a director during the election of directors at a general meeting of the shareholders. prevention of oppression and mismanagement, a representative action may be brought for prevention of oppression and mismanagement, which are cases where the majority acts in a manner that oppresses the minority, where the majority acts in a manner which oppresses the minority, or where the affairs of the company are being conducted in a manner prejudicial to the public interest or oppressive to any member or members, or in a manner prejudicial to the interest of the company, including an adverse material change in the management or control of the company. Since these proceedings are initiated for the benefit of the company, it can be considered a form of derivative action and find specific place in the scheme of the Indian Company Law under the Companies Act. In order to obtain relief, the Company Law Board can be approached by not less than 100 shareholders or not less than 1/10 of the total number of members, or members holding not less than 1/10 of the issued share capital of the company, provided all the dues of the shareholders have been paid by the applicants. Last action which the shareholders are allowed to take is the class actions. This class action, the provisions regarding the class actions were not there in the old Companies Law. It is in the Companies Bill 2012 that the idea for to include this class actions were recommended by the J.J. Irani committee. What the committee recommended in its report is, in case of fraud on the minority by wrongdoers who are in control and prevent the company itself bringing an action in its own name, derivative action in respect of such wrong non-rectifiable decisions have been allowed by courts. Such derivative actions are brought out by the shareholders on behalf of the company and not in their personal capacity in respect of the wrong done to the company. Similarly, in the principle of class representative action by one shareholder on behalf of one or more of the shareholders of the company or of the same kind have been allowed by the courts on the grounds of persons having same locus standi. So, class suit is not limited to corporate law, but extends to the whole realm of civil procedure. In fact, class suits are not so much a provision of law as a procedure. For example, Order 1 Rule 8 of the Code of Civil Procedure 1908 provides that where there are numerous persons having the same interest in a suit, one or more persons may, with the permission of the court, can be joined together to sue or defend the suit for the benefit of all interested. Subrule 2 provides for the power of the court to publicize a representative suit either by service or, depending on the number of persons involved, by public advertisement. So, the procedure has widely been used in India for what is commonly termed as public interest litigation. Now, this recommendation was considered by the Parliament, and when they enacted the new Companies Law, that is on 30th August 2013, the section 245 contains the provision with regard to class action. The concept of class actions and derivative actions are almost very close to each other, because in both the cases the shareholders in the representative forms are taking action against the wrong done to them or against the interest of the company. In fact, at the time of proposing the addition of this provision in Companies Law Bill, it was not clear that whether the Parliament was seeking to introduce the class action provision or the derivative action provision. So, basically these 2 points are something very close to each other, and hence in the finally in the Companies Act 2013, the Parliament have inserted the class action in provision section, that is section 245. So, what we have discussed in this modules are the 4 important points, like what is the oppression and mismanagement, that is the concept of oppression and mismanagement. Then we discuss the majority versus minority rule, that the minority rules cannot be suppressed by the act of the majority rule, they need protection. Then the rule of force versus Harbotel, which lays down that suppressed rule that the court should not interfere, and the Indian courts have given an exception to this rule. And then we have discussed the remedies which are available because of that exception, because we have made that oppression and mismanagement are the exceptions to this rule of laid down in the force versus Harbotel. So, because it has been made an exception, the remedies which were given to the shareholders are like personal actions, derivative action and class action. Personal action, derivative action, class action, these three actions were not recognized in the statute, in the Companies Law before the Companies Act 2013. It is only in Companies Act 2013 where this class action provision related to class action, that is section 245 of the Companies Act 2013, this new section has been inserted, and now whenever the shareholders get suppressed by the acts or by the frivolous acts of the majority shareholder or the wrongdoers, they can take a class action in a civil suit but in a representative form. So, this is the whole discussion which we have made in this module. Thank you.